Well, good day, everybody. Pasquale and I are delighted to have the opportunity of introducing you today to the 2021 Yearbook of the Observatory on the Protection of Taxpayers' Rights. As we have done in recent years since the IFA Congress in Basel in 2015, the staff of the Observatory have brought together a variety of developments that have occurred in the last year by way of a summary on the changes to the protection of taxpayers' rights in 2021. And Pasquale and I are going to highlight a number of those developments. Now, of course, 2021 was the year in which the world began to come out of the COVID pandemic. And one of the consequences of that was that a number of measures that had been introduced during the pandemic, which had an impact on taxpayers' rights, were either continued or they had consequences. For example, during the pandemic, it was very difficult in many countries for taxpayers to personally go and deliver tax forms or have meetings with tax officials. And so new systems were introduced for remote meetings or remote filing of tax documentation. In some cases, that process has significantly assisted in the access by taxpayers to the tax officials, because taxpayers who were remote or who had access difficulties to physical offices were able to continue to use remote meeting facilities. And that we can see as a positive development that is a positive result from the pandemic. The introduction of methodologies for remote meetings and remote filing of tax returns there. On the other hand, there are other aspects of this that perhaps are not necessarily positive. What about some of those, Pasquale?
Well, one of the points is also that there has been, in many cases, it has been not possible to meet the deadlines. So the positive is that there has been a relaxation of the deadlines. The negative side is that there has been a backlog of activities which have to some extent turned into a major burden for the taxpayer. That is not just connected with formal obligations, but also the fact that during the pandemics and during the period of force majeure, the governments have admitted some postponement of deadlines. So at the end of this period of pandemics, then we have turned into a situation of backlog. And this has been also perceived already in the facts reported for 2021. So summing things up for the first of our selected topics, so the developments connected with COVID, there have been challenges turned into opportunities. And I think that this replacement of presential meetings with virtual meetings is certainly one. And also the fact that there have been relaxation of some deadlines. I think it's something quite good at times of force majeure. But then certainly we have to try and get back to the normal pace. And that is what is making things more complicated. So, negative and positive sides, but the observatory and our report from the entire world brings you relevant examples and also trends. Now, I think, Philip, we could move on to a second topic, which in my view is quite important to address, and that is the challenges connected with confidentiality. 2021 has been an important year also at the level of the European Union for some enhancement of transparency in tax matters, but that is not necessarily going in the right direction. So we have seen that the public country-by-country reporting directive was approved, and the implementation of this directive, which has not been entirely completed, also shows that there are some important challenges. In our 2015 general report, we have expressed concern for the fact of having some data being publicly disclosed without the authorization of the interested persons. Well, for us in the European Union, that is certainly problematic because of the fact that we have the General Data Protection Regulation. And I think that the point that with the observatory we've been making in the past, that as long as there has been no public disclosure of this data, the access to the data by tax authorities is certainly something which is to be protected and preserved. But that doesn't go as far if we consider country by country reporting as turning that into public country by country reporting. Public country by country reporting could make the overall community becoming aware of what multinational enterprises do. But at the same time, it could also disentangle potential forms of boycotts or other situations in which, in case of improper accusation, meanwhile, there are difficulties which could be avoided. So I think that it's important to stress once more that these measures are disproportionate, and at the same time, if country by country reporting is good, public country by country reporting turns into some kind of opportunity to get back to naming and shaming policies, which we have noted throughout the world. They continue to be popular, and they are one of the potential modern threats to confidentiality. And that is also in parallel with another form of threat, which is connected with the excessive reporting obligation. So the fact that we have seen intermediaries being obliged to report suspicious transaction is something which in the European Union has been developed also as to the implementation of the BEPS project in the so-called DAC 6. But elsewhere in the world, we have seen that that has exponentially grown, creating obligations, such as in the case of Mexico, to report suspicious transaction without having more clarity as to what circumstances would be such, and when there is such obligation in fact. So those blurred lines are quite problematic. But Philip, I don't think we want just to report on negative developments happening in 2021 on confidentiality. Perhaps it's also good to mention the good things that happen on confidentiality.
Well, there's an interesting development here that relates to confidentiality, and that concerns the whole issue of whistleblowing. And if one thinks about this, there is an element of danger and an element of positive result here. The danger, of course, is that whistleblowing can result in the public disclosure of confidential information that taxpayers would have wished not to be made public. On the other hand, a true whistleblower is acting in the public interest in making known to the public potentially damaging activities, including tax evasion or extremely aggressive tax planning. And on the area of whistleblowing, the balance has, in a sense, been positively reflected in two respects. Firstly, within the European Union, the whistleblowing directive has been introduced, which ensures that those who are genuinely engaged in whistleblowing, that is bringing to the public attention truly damaging situations where there's a public interest, that directive now protects the whistleblower. On the other hand, we've had the rather interesting litigation before the European Court of Human Rights in Strasbourg involving the Lux leaks and Mr. Hervé, who was the whistleblower, who subsequently was found guilty of an offence in Luxembourg, took his case to Strasbourg. The initial chamber judgment in the European Court concluded that having regards to the particular circumstances of what is and what is not a whistleblower, that there was no breach of the European Convention. But at the end of the year, the case was pending before the Grand Chamber, and we will hear from the Grand Chamber of the European Court on this important issue of whistleblowing. So there are potentially positive developments there which ensure that whilst on the one hand confidentiality is observed, on the other hand information where there is sufficient public interest to merit its disclosure by a whistleblower, the whistleblower is able, without any risk of punishment, to go ahead and carry out that public function.
Yeah, the balance is always particularly difficult, because if we don't come out with balanced solution, then it's perhaps not working. And we see that also in an area which I think goes from the audits to penalties. And I think it's quite important to stress that in 2021 there have been problems connected with the levying of penalties and sanctions in the area of taxation. And on the positive side, I would like to say that the intervention of the judiciary is securing that balance. And we have an interesting judgment from the Constitutional Court of Slovenia, which has declared that a 70% penalty surcharge is regarded as disproportionate. And this is something which, in my view, is also important, because it's different to determine what is in line with the goals of a given sanctions. We have sanctions of different types. We have penalties and we have criminal sanctions. Now, normally, criminal sanctions should be the one addressing the most severe cases of violation, and penalties are just sanctioning the less severe ones. But when you go and you decide to use a penalty, if the amount of the penalty is significant, then you end up in a situation in which you create some deterrent effects, which could perhaps be at odds with the very function of having something not sanctioned in a criminal way. So there is this dilemma, and it's more generally a dilemma which is connected with a lack of clarity from a conceptual perspective as to what is needed in order to levy a sanction. So whether there needs to be an assessment of the willingness, so the subjective element, and in that the answer is potentially yes for criminal sanction and perhaps also for administrative sanctions. But for surcharges, one might just think that the mere failure to make a timely and full payment of what is due in terms of tax could be enough. Either way, I think that the positive development that Slovenia has recorded is not indicating a general trend, because I think, Philip, the general trend in the use of penalties is not really going in the direction of softening the reactions.
Yeah, a number of the reports that form the basis for the yearbook noted both the increased use of criminal penalties over the last couple of years, but also the increased severity of the sanctions. Now, that can have a negative and a positive effect. The negative effect is obviously that taxpayers risk higher sanctions, greater possibility of a criminal penalty. On the other hand, in principle at least, greater safeguards should apply in the case of a more intensive audit. I'm not certain, though, that it can actually be said that necessarily the trend towards greater use of criminal penalties has been matched by an increase in the safeguards surrounding the more intensive audit. So that's an area where one can potentially see both a danger and also the possibility of enhanced safeguards. The reports show the increased use of penalties, but not necessarily the increase in safeguards at the present moment, and it's something that one needs to particularly watch going forward. One area on legislation concerns the element of government introducing retroactive tax legislation. And here it's pleasing to report both a positive, well, really two positive developments and nothing negative. On the positive side, Luxembourg, Pasquale.
Yeah, Luxembourg has been bringing a very interesting case forward in 2021. And that shows that there is sufficient awareness of the threats to legal certainty that retroactive legislation, either directly or indirectly, poses. And I think that this is quite encouraging also because it doesn't emerge as an isolated trend from Luxembourg. This is something which has reached some level of maturity, and I think it's an important message that we get from courts for the legislator, also because in the draft directives that are being proposed, there are some kind of hidden forms of retroactivity which can undermine the legal certainty. But as I said, Philip, I think this is a more general trend and a positive trend that we don't see just from Luxembourg. I think we have recorded also elsewhere in the national reports.
Well, in the case of India, there are, in a sense, three elements that the reports point to that show very positive developments in this area. India being historically one of those countries that has used retroactive tax legislation in more extensive circumstances than others. And firstly, the current Indian government has indicated that they are generally not minded to use too much retroactive legislation. And I think it's right to say that since the current government has come into power, they have avoided the use of retroactive legislation. The Indian Supreme Court has also, in quite strident terms during the period covered by the Yearbook, rejected an argument that a change with regard to the taxation of royalties that was argued to be retroactive. They rejected that completely. And then finally, perhaps stepping outside of the national level to the arbitral level, the arbitration body that determined the cases involving Vodafone and particularly the Cairns arbitration, which involved retroactive tax legislation, the arbitral bodies came down very clearly in favor of the rule of law and the limited use of retroactive legislation. The Cairns arbitral award in particular is very precise and very clear in its identification of a small number of limited circumstances where retroactive tax legislation might be justified. The general principle they assume is that changes to tax law should be prospective in effect, and that only where there is in effect no undermining of legitimate expectation can it be acceptable for a government to introduce retroactive legislation. What one rather hopes that other arbitral bodies, the decision of an arbitral body is not a binding precedent, but that other arbitral bodies will follow that approach, and that governments more generally will take a limited approach, allowing retroactive tax legislation in only a very narrow range of circumstances. So that brings us on to final development that one might highlight. The reports in the yearbook have chronicled from year to year the growth in the adoption of taxpayers' charters or taxpayers' bills of rights around the world, so that a significant majority of countries now have either a taxpayers' charter or a taxpayer bill of rights. One development in this area, which is very much ongoing, is the proposal from the European Union to adopt at the union level a taxpayers' charter. Of course, the European Charter of Fundamental Rights has started to give rise to case law from the European Court of Justice, and that case law has been picked up by the yearbook, particularly those who contribute to the yearbook analyses of the case law from the European Court of Justice and from the European Court of Human Rights. And that particular work of the people compiling the yearbook is, I think, particularly valuable if you're interested in those developments. But developing from that case law, the European Union is working on a taxpayers' bill of rights, and we'll be interested to follow that as it emerges.
I think we have given you a picture of how things have developed in 2021. We hope you'll enjoy our observatory and read our full report. Thank you.